Good morning and welcome to the Brazilian American Chamber of Commerce's 9th edition in the webinar series, COVID-19, What Lies Ahead. This one is on insolvency, bankruptcy, and distress acquisitions in Brazil. I am John Welch, Executive Director of the Brazilian American Chamber of Commerce, and on behalf of the Chamber, we wish you all health and safety in this difficult time. We also wanted to thank you for joining and thank Proskauer and Rose for sponsoring this event. The world is reopening following the COVID-19 lockdown. New York City started yesterday, while the state of Sampaio has published similar criteria opening different regions of the state. And we've seen that across all of Brazilian states as well. The economic and business toll, however, will prove significant. Today, we bring together a panel of renowned experts to discuss the legal and financial opportunities and challenges involved with cross-border acquisitions and restructurings of Brazilian distressed assets in the aftermath of COVID-19. The panel is extremely timely considering the advance of bankruptcy and insolvency reforms moving through the Brazilian Congress. Our moderators today are Marcello of Jones Day and Antonio Piccirillo of Proskauer Rose LLP. Marcello is a partner of Jones Day and has long experience in advising multinational companies, financial institutions, investment funds throughout Latin America and around the globe. His practice focuses on cross-border mergers and acquisitions, joint ventures, privatizations, private equity projects, and other financing and strategic transactions. Tony is the head of Proskauer Rose's São Paulo office and a member of the Latin American practice group, and also as a director at the Brazilian American Chamber. His practice focuses principally on transactional and financial matters in Latin America. He has extensive experience in bank finance, securities law, corporate governance, especially Sarbanes-Oxley compliance, capital markets, project finance, debt restructurings, including tender offers, consent solicitations, and exchange offers, securitizations, and mergers and acquisitions. You can find the full bios of all the panelists on the invitation link and on the Brazilian American Chamber website. Before turning the screen over to our moderators, I would ask you to please use the Q&A tab for questions. You can make them at any time, and we will look to answer them after our guest comments during the Q&A period. Thank you very much. Marcelo and Tony.
Thank you very much, John. This is Tony Piccirillo from Proskauer. I will just sort of kick this off. First of all, it's a real pleasure to be part of this What Comes Next or What Lies Ahead series. As you mentioned, John, the topic today is insolvency. And why are we talking about this now? Well, as I'm sure everyone knows, Brazil has been in the process of reforming its existing bankruptcy law for the last few years. Those reforms are working their way through Congress now. The existing law is actually only 15 years old. It was a huge improvement from the regime that existed before, and that was quite rigid. But I'm sure everyone here will agree that the existing regime has resulted in relatively low recoveries for creditors, compared to international standards, and the process can drag on for extended periods, and therefore the proposed reforms that are working their way through Congress should, in theory, be more favorable to creditors, and it should facilitate more expedient and more productive restructurings. Now, everything I said up to this point was true before COVID, and now after COVID, it's even more true, and the stakes are higher. We're about to see more companies seeking protection against creditors. And also, we will see more opportunities arise for investors that have the appetite for it. And so that's why we're here. We're going to discuss the opportunities that exist under the current scenario, what obstacles there might be under the current regime, how the proposed reforms would alleviate those obstacles, and finally and importantly, the interaction between proceedings in Brazil and in the United States, so that we can talk about what every company should consider before they file, and where they file and what they file in that jurisdiction. So having said that, I will pass this off to my co-moderator, my friend Marcello Hallake from Jones Day.
Hi, now I think you can hear me. Good morning to all. Thanks, Tony. Thanks, John. It's a pleasure to be with you all this morning. And basically, I think that as these things go, for people like me and Tony, who have been working as transactional lawyers throughout Latin America for our careers, we tend to go through different phases, and they come and go. And sometimes it's like boom and bust. And so sometimes for us transactional lawyers like myself, more M&A lawyers, we tend to sometimes focus more on, privatizations, capital markets, IPOs, more financings, more at other times, more anti-corruption issues in acquisitions, and what we are not yet seeing, because it's still early, but what we are expecting to be seeing more, unfortunately, for Brazil and for the world and for many, is probably more insolvency and bankruptcy issues, and that's why we are, that's why we are going to be talking about this at this time. And so to do that, we have put together a panel of very experienced speakers, most of them lawyers, but we have Otávio Guazzelli from Moelis, who is the non-lawyer, although I do think he has a law degree, but he will be giving the investment perspective, as he's the co-head of Moelis in Brazil, and as such he and his firm have been working extensively on restructurings in Brazil, including the famous restructuring of Oi. Before being with Moelis, he was with BR Partners and with Citi. So his perspective will be very interesting. And the other panelists are seasoned bankruptcy, insolvency, restructuring lawyers, starting with Thomas Felsberg, who is a very experienced, well-regarded senior member of the bankruptcy bar in Brazil, founded his own well-known law firm, Felsberg Advogados, and for many years have been working on most of the high-profile bankruptcy and restructurings in Brazil, and will give us his perspective. And Marcelo Ricupero is also an excellent and very experienced and well-regarded lawyer, partner with Filho, who advises regularly on also the highest profile and most visible restructuring transactions in Brazil. And then we have Tim Karcher, who is a partner with Proskauer in New York, and who is a bankruptcy insolvency focused partner at Proskauer in New York. And his perspective will be very interesting because, as Tony said, in cases involving investors, bondholders, creditors that are based in either the US or outside of Brazil, or companies that have assets that have in the US or outside of Brazil, many times there will be a kind of an interplay between filing in Brazil and in New York or elsewhere, and we will be discussing that. So to start, I think that it would be good if Otávio, in particular, could give us a kind of an overview of what at the moment are given the challenging economic scenario, what are the opportunities for distressed acquisitions in Brazil, from a sort of an investment perspective. and maybe Marcello can add some perspectives on from a legal perspective. Otávio, can you do that?
Yes, sure. Thank you, Marcelo, and good morning, good afternoon to everyone. And it's an honor to be here in the middle of all these lawyers. I have not completed my law degree. I have a business degree and my unfinished law degree. But anyway, on the acquisition front, it's an interesting moment because while there are many opportunities, because you see companies with a need for liquidity, the fact that the Federal Reserve and the European Central Bank, they have acted so quickly in the market and injected a tremendous amount of liquidity in the market, in global markets, have created distortions as well on asset prices that are very significant. There is, for example, one company in the US where the debt is trading at 5 cents and the market cap of the company is $650 million. So it's a company that should be filing for bankruptcy in Chapter 11, and as you know, the equity gets wiped out, and you have this distortion. And the same thing is, to a much lesser extent, but the same thing happens in Brazil as well. There is still a lot of distortions on asset prices. And for some reason, and well, the reason is the liquidity injection, but it's not really pricing what will be really the most likely scenario in terms of recovery. And also the market is not pricing very well the liquidity needs of these different companies. So having said that, as a background for the opportunities, what we see in Brazil as well is that the bank loan market on this crisis has evolved significantly when you compare to 15, 20 years ago. So that has been a slow development, and you see much more transactions happening in the bank loan market, where distressed assets are being traded. Not as much as we would like, and it would be important for the economy to have liquidity for those assets, because most of the banks, they keep holding the assets in their balance sheet, but there is much more trading. So there is much more opportunity on that front. Actually, we're currently working on a situation that really represents what I'm saying now, and it's something that would not have happened in the previous crisis. So now the banks have put together restructuring teams. They have dedicated areas, and in most of the cases, those areas, they have a P&L. So they are acting much more quickly in order to sell underperforming loans. On the bond price, on the capital market side, local capital markets is relatively small. And when you look at international bonds, where there is most of the issues are concentrated with the large companies in Brazil and so on. So the opportunities are very spotty, and it depends on windows, let's say, of opportunities to do so. In the recent 2 weeks, the market has recovered significantly based on some of the drivers that I mentioned earlier, the liquidity injection. But still, the scenario is very uncertain. So we have seen few trades so far. International investors, they were, for most of the time since February, focused on 100% on the development markets. In the past, again, 2 weeks, 3 weeks or so, with the recovery in the developed markets and so on, and somewhat of a let's say, light at the end of the tunnel, they started focus on emerging markets. So there was a significant recovery in asset prices for emerging markets as well, including Brazil, as we saw. So there was a much more trades in the past 3 weeks, 4 weeks than we had seen before. Before the market was basically frozen. So in a short summary, that is the background. I'll pass the word back to Antonio or Marcelo Hallake, and then we can take it from there.
No, thanks for that, Otávio. That's very interesting, particularly the recovery aspect from my perspective. Marcelo, Ricupero, could you chime in and give us what you're seeing?
Sure. Well, good morning, everybody. Marcelo, Tony, and the Brazilian American Chamber of Commerce. Thanks for the invitation. The colleagues from the panel. Well, it's interesting because I think from a legal perspective, we have the same perception that Otávio. I would say that in terms of M&A in distressed assets, we actually see more movement on the ongoing cases rather than new cases. So, the OI, which is, and this is all public information, the amendment of the plan that OI is planning to file to sell some assets, or Rodovias do Tietê, which is also an ongoing case, or the Brest that, that there's always the expectation about a transaction involving Braskem, and also this fight over Atvos between creditor and Odebrecht, and some new cases, but that there are not really new cases like GVO and USJ, which are companies that are going semi-restructuring or on the verge of restructuring for a few years. So this is more the cases that we are seeing movement and interest of investors. I think in terms of new cases, and we know that by the data that there has been an increase in filings and even bankruptcy requests, but I think this is more related to small or mid-sized companies. I think the large companies are still doing what Otávio has just said. They are taking advantage of the liquidity. They are able to get, some quick money from banks, negotiating standstill, trying to push things for 60, 90 days, see what comes, what happens, how the world responds. And then we will see what happens to these companies. Some of them will be able to work it out. Some of them will have to file. And then maybe we have more movement and more M&A transactions of new cases. But in terms of expectation, I think there's a general expectation that consolidation will be a big factor, maybe 2 or 3 months down the line, when we kind of, it's clear which of these companies have managed the crisis better than the ones and that didn't, and those will probably get be the target of consolidation movement.
Okay, great. Thank you, Otávio and Marcelo. So it's clear that there certainly are opportunities out there. I think the next logical question is, okay, well, what obstacles currently exist right now under the current regime that investors have to deal with in this situation? And I'm going to go back to Otávio for his view from an investor's perspective, and then we can get Thomas and Marcelo to comment on the legal perspective.
Yes, no, thanks, Antonio. Look, the obstacles that would be really great for the economy and for the companies and so on to overcome are known, right? I think one of the obstacles is dip financing, right? The companies, they go into a restructuring in Brazil and they have really zero access to liquidity. We do not have they don't have the ability in practical terms, although there is some legislation, but in practical terms, it doesn't really work, the dip financing and the ability to raise money during that period. That has a significant impact on recoveries. It's because the companies, they are at the end of the line, they're extremely weak. They are operating with very low levels of profitability, and they lose competitiveness. Now, most of the companies that go into this situation, they operate in a competitive market with a few exceptions, and that they need to invest, they need to continue to have commercial actions and so on. And then they stay 12, 18 months basically frozen and with no access to liquidity. When they emerge, they're very weak from a competitive point of view and from an operating point of view, and that has a significant impact on recoveries. So the number one thing would be really ability to raise capital during the restructuring period. The second thing is ability as well to change the plan. I think OI case is highlighting this issue, and it's going to be also a very important precedent for everyone here, given the magnitude of the case. But that issue actually we see all the time. It's very difficult to have a plan approved and then you have to conform to that plan, and you have very little flexibility. One thing we know for sure from a financial point of view when we do a business plan is that that business plan is wrong. No, that we know. That we know for 100%. I think very rarely I see a business plan that actually is correct, because it's to make projections. It's very difficult. You know, it's probably the most difficult thing to do. So anyway, it's important to have in the legislation ability to change the plan and a mechanism to do that in a way that is efficient. I'm not saying that the company should have leeway, you know, to do whatever they want. It's not that, but that there is a mechanism that is efficient and to get approval with the relevant stakeholders in order to change the plan and make sure that the company can adapt to the economy and adapt to the new needs of the consumers and so on. And you have all sorts of things. The other thing that creates a lot of uncertainty for investors as well is the fact that in Brazil you have the substantive consolidation, right? So people really don't know when they're buying a debt, you know, like what is the waterfall now for that situation. And there is a lot of uncertainty on that. And it seems that from the perspective of the investor, that this almost is it's a decision of the company, what they think they should do. Oh,
we might be having technical difficulties with Otávio, but while we try to work those out, maybe Marcello, can you give your perspective from the M&A side on what the obstacles are in the current environment?
Yes, sure. I think another obstacle is time. You know, I think if again always considering the larger cases, we would say that, and also probably taking away as an example, the time for a plan to be approved in Brazil, it's, I think, much closer to 12 months than the 6 months that was contemplated by the bankruptcy law, right? We have a stay period of 180 days, which assumes that within that 180 days, a plan was going to be approved. And this is very rarely the case. I think it's really closer to 12 to 18 months. So things take a long time. And for M&A transaction, I think time is really important. And especially in a situation of a company that has its, you know, cash constraints, as Otávio said, does not have any, you know, much alternative in terms of raising liquidity. That changes a lot the value of the asset. And there are several transactions that, you know, just fail because, you know, how long it takes to get it done. And that also brings me to the second factor, which is, in addition to time, also something that is related to time, which is the amount of appeals that you have in Brazil. So you have the plan approved, and then creditors can appeal. They can ask for a stay effect in this appeal, which can freeze everything. And even when you have the competitive process to sell the asset after the plan is approved, it's also not rare situations where a creditor then files an appeal, try to dispute the sale transaction, try to discuss any aspect of the sale. It's not competitive enough. If you give some advantages to a buyer, you know, like a stalking horse, some kind of breakup fee, right to match or this type of advantages, they normally also get disputed. So I would say the amount of appeals also is a factor. And the third one, from an investor perspective, is uncertainty, right? I think I just can't count the times that clients called and said, "Look, it doesn't matter if it's bad. I just want to know what's the path forward." And sometimes we just don't know. If you are talking about a specialized court with precedents, it's much better, because then you can kind of say, look, this is what we expect. This is how long it usually takes. This is the decisions that we had in the past with those advantage, gross up, or whatever it is. But if we're talking about a city with no specialized court, we just don't know, and you just can't say, and there is no expectation that you can give to your client. And all you guys know that from an investor perspective, this uncertainty also is something that really kills the deal. Maybe a final comment, which is I absolutely agree with Otávio that deep financing is an issue in Brazil, but I think there is one interesting feature, which is deep financing as a bridge to acquire an asset normally works well, because again, you don't have much competition. Normally the only investor willing to give you a deep financing is the same investor that wants to buy the asset. So using that as a bridge to finance the acquisition, a way to provide liquidity to the company, deal with these uncertainties, the time that takes to get a deal done. This is something that normally works well, but I think, and I agree that this is an exception to all the issues that we have with the financing in Brazil.
Great, thank you. Sorry, Marcelo. I was going to say thank you very much, Marcelo and Otávio. Marcelo, Hallake, unless you wanted to ask them a question, I was planning on asking Thomas for his.
Sure.
So, thank you. Thomas, I think we just heard here a litany of some of the major obstacles that the current regime presents, from the difficulties around dip financing to difficulties in changing a plan once it's been approved, uncertainties regarding substantive consolidation, just the general timing that the 180-day period isn't realistic, the number of appeals that can be filed, and just the general uncertainty around what the outcome of the process would be. You are probably more familiar than anyone else on this webinar with the current regime. Would you agree that those are the major obstacles, and are there others that we're missing here? And then perhaps you can tell us how the proposed reforms are going to try to address some of these points.
Thank you, Tony. And thank you for the chamber for this opportunity. Yeah, I think Otávio and Marcelo Ricupero, they highlighted very well all the different obstacles and things. What is striking about Brazil is that it's always amazing, because each case is different, and each case in some way finds a solution navigating through all these difficulties. You take all the larger cases in Brazil, for better or for worse, there was a resolution. Some cases, the resolution wasn't very good. Other cases, we have some success cases here, of large companies which reached a satisfactory resolution. Insolvency is usually a complicated matter. In Brazil, in addition to the matters which Otávio and Marcelo mentioned, you have to be very careful in your due diligence and ascertaining what you see. You have labor issues. If you file, they have to be they have to be paid within 1 year of the date of approval of the plan. You have the whole tax situation, which is outside of the restructuring, which requires the due diligence. Amazingly, there are many companies which are okay, and many companies which are very bad. So each case is quite different. We do have a free and clear sale of distressed assets in judicial restructurings, our Chapter 11. We have a pre-pack, which has been used in some issues now, very recently, that are Stocky case and other cases, where this has been a solution. It does require a lot of negotiations, and as Daniel Carnio, who was a former judge at the first bankruptcy court here in São Paulo, mentioned, he said that the lack of specialized courts is a problem, but it's a problem which is being resolved as the number of insolvencies have grown in the whole court system. You take, for instance, the issue of specialized courts, which is very important, you know, and this also involves appeals courts, where many times judges see insolvencies for the first time in their life, and of course it's difficult to grasp. It's a complex issue. But what is the National Council of Justice proposing? That each state, it's a matter of state law, you know, the jurisdiction of the state courts over bankruptcies, distributes the bankruptcy cases in larger districts. The law says that it's the law of the principal establishment which gives the venue for an insolvency proceeding. But if this venue is transferred to specialized district courts, you know, you take a state like São Paulo, which is perhaps the largest state, the Tribunal de Justiça, the Court of Appeal of São Paulo, is studying the possibility of dividing the state in 4 districts or 5 districts, in which specialized courts would be installed and the larger cases would then flow to these districts. And that would be a major improvement. We have in Congress now a law which has been brewing now for a few years, and which has the support now of the administration, has the support of Congress. It has already passed all the commissions and is ready to be voted. And it should have been voted. And this would have modernized the Brazilian bankruptcy law in many respects. I take, you know, I don't want to bore you, you know, with all the aspects. You know, this could be a discussion for an entire webinar or a series of webinars. But take one aspect. There is the ancestral law for uniform law for cross-border insolvencies. This would be adopted if this project, the 10-220, would have been approved yet, and should have. It wasn't because of the COVID. Now, this means that we would be able here in Brazil to give effect to a Chapter 11 in the US and recognized in other countries. You take the Latam case, for instance, where if you look at the proceeding in the US, you have these first day motions, you have rejection of contracts, you have abandonment, you have the DIP loans, you have all these measures, and you have highly specialized courts who have presided over 150 restructurings of airlines, where case law is very, well, you know, I'm preaching to Tim is here. He will probably give a much better explanation than I as a Brazilian law witness. But as I compare the systems, you know, and the difficulties which Latam will face in Brazil, where Chapter 11 will not be recognized, this would be an incredible improvement, you know. You have other matters, you know, for instance, this system in the US where there is a priority for the debtor to present a plan, but then creditors could present their own plan. So if this project is approved, this would happen. I personally, I participate in a few committees which are looking at this, and I have been striving for a 363-like mechanism where instead of selling parts of a company free and clear, you sell the whole company. It's still possible. We've done it in the past, in several instances. But if this is better discipline in the insolvency law, if we have this could facilitate and be a game changer here in Brazil. If you could add the, taking out some of the uncertainties which Marcello mentioned. If you sell the entire company, we have these the timing factor, because all the credits which accumulate, the post-filing credits, they must be dealt with when you have a distressed acquisition. So basically, there is a need for a law reform. It's a pity the law reform has not passed. It is in Congress. It's just ready to be voted by the House, but there was a decision by the Congress to only focus on legislation related to the pandemic right now. So this was delayed. So we have to see what will happen as Congress focuses on other reforms. And this would be probably one of the first reforms, because as I mentioned, the Ministry of Economics has approved this change. We have a group of about 25 bar committees and different associations, including the TMA and other, the banking, FEBRABAN, the Federation of Banks, the industry. Everybody is aligned with this process of law. So although there are critics and although there are, of course, discrepancies in all this, and although the reform is not what we would aspire to in an ideal world, I think this is a reform which could be adopted quite quickly once this pandemic thing is over, and this reform could be a game changer. But even now, with existing norms and the rules and the difficulties and the uncertainties, from my perspective, all the larger cases and the more important cases were in one way or the other were dealt with, and we have found resolutions. Maybe they could have been better. There is a study which shows that the credit recovery in Brazil is less than the credit recovery in other Latin American countries, and there is space for progress. But this is one of the motives why this larger for these two matters I mentioned, but I could mention 10 or 12 other reasons why it should be adopted.
Hey, Thomas, that's very helpful. Now, I think that Otávio, who seems to have a lot of difficulties in reconnecting, and Marcelo both mentioned the lack of deep financing as one of the big problems. Is there any prospect, Thomas, in terms of the new law or proposals to have deep financing more available in Brazil?
Yeah, the new law provides for an approval of the deep financing, giving the creditors a chance to object and a court ruling and to make it more efficient. And also, one of the uncertainties is how we have all these credits which are not subject to the restructuring, meaning credits where the creditor has title to the security, like chattel mortgages and other credits. So basically, this new project tries to streamline somewhat more the priority, which is already given, to debt financing. There is a priority given, but there is uncertainty as it competes with other credits, for instance, the ACCs. it's quite clear that if there's a chattel mortgage, the creditor has right to that specific security, and so the DIP creditor will not have access to this. And we don't have this cramming down, you know, on secured creditors here in Brazil, and this is not in the project. But certainly there are improvements, and you know, if you look at the entire picture, the DIP financing will become a reality. The DIP financing right now works if coupled with chattel mortgages, with these alienações fiduciárias, because these and this is established law, you know, they prevail over all the other credits. So in specific situations, a DIP finance, as Marcello mentioned, especially if there is an acquirer in the picture, works well because you can secure, you can guarantee this DIP finance with this chattel mortgage, and this works even if the company then goes down the drain or is liquidated or anything. That security, the assets which are given to the creditor will prevail. So, as I mentioned, although very difficult right now because there's a lot of institutional change, each case there is a way to navigate through these difficulties and find solutions to mitigate these risks. But, you know, Otávio and Marcelo are obviously right. These risks exist, and they have to be very carefully considered, and also the factors which mitigate them.
Thanks so much for that. I see that Otávio might be on or not. Yes. I know you're having troubles. I'm sorry about that.
Otávio, I'm sorry. I have not been able to fix the background on this new device here, but I got disconnected.
That's fine. When you were disconnecting, Otávio, you were talking about what you saw as challenges.
Yes.
And you talked about, yeah.
I was going to say something that is always a problem, is a tax, right? That we have in Brazil as well when we restructure the capital structure of the company, which is something that doesn't make any sense, obviously, from a corporate finance point of view. But in Brazil, you have this sort of like a taxation on the restructure, on the haircut and so on, which makes most of the time we find a solution for that, but it's costly, it's not ideal, and it really again damages a lot what would be the recovery of the company. So this is another change which I think is probably the most difficult one to be implemented, I would guess, but that would make also a significant improvement in the efficiency of the process. That was the point I was going to raise when I got disconnected.
If I may add, I agree entirely with Otávio. In this process, there are two things. One is the possibility to offset past losses with the haircut. The haircut would still be taxable, but you could offset losses without these provisions that you have the tax carry forward limited to 30% of future profits. So, and they would clarify also an issue which is controversial, which is the PIS and COFINS on the haircut. So, and also provide for 120 installments to pay the debt. So the project doesn't resolve the tax issue. It could be more advanced, but it diminishes some of the concerns which Otávio has mentioned.
All right, thanks for that. I wonder if we could switch to Tim to provide a perspective, a U.S. perspective perhaps, and tell us, Tim, you know, why would a Brazilian company, a Brazilian debtor, might want to consider Chapter 11 or Chapter 15 as opposed to or in addition to filing in Brazil? How does that work, and what are the advantages of using, or disadvantages of using, U.S. jurisdictions? And also, I would be curious also, based on what you on your experience and what you hear, what you've heard as being the challenges in Brazil, if you can give comment from a U.S. perspective, how these compare to the extent possible to what there is in the U.S. and how you see these challenges.
Sure. Thank you very much, and thank you to the Chamber for the invitation, the ability to speak. I'd like to start, I think, with some of the challenges first, and kind of go through them, and that might springboard into a discussion of Chapter 11 and Chapter 15. If you've been involved in a Chapter 11 in the United States, you know that we do have DIP financing, and it's really central and key to having liquidity during the pendency of the Chapter 11 case. And typically, the DIP lenders who are providing the financing are the incumbent lenders who are in most cases secured and would have the ability to foreclose on the assets or hold a security interest. And the DIP financing provides them with an option to see if somebody else can purchase the assets in a 363 type sale, whether you can restructure and reorganize in a Chapter 11 plan and emerge with a company that's been delevered. And so the DIP financing here really is a key driver to the process. And that key driver deals with a lot of some of the other issues that we talked about in terms of problems or issues in a Brazilian restructuring, including the timing and the certainty and the ability to change the plan. Because the DIP financer typically comes up with case milestones and sets dates by which certain things must happen. And those dates are set very early in the case. Typically in connection with the DIP financing motion, they'll say, if we don't have a plan within 120 days to sell this company, then we're going to convert the debt to equity, and we'll restructure it in that particular way. One of the other things that you talked about was the timing and how long cases can take in Brazil. In the US, we are seeing cases that go very, very quickly. In reading the current legislation or the current restructuring regime in Brazil, I noticed a great deal of similarities between what you have in Brazil and what we have in the United States in terms of what we might call a pre-negotiated or pre-packaged plan, where you do an out-of-court agreement and then you bring it to the bankruptcy court to have it blessed and enacted. And that can happen, and that happens very frequently in a very, very short period of time. Now, I understand that the reforms that Thomas was speaking about and we've been speaking about, they're prospective. They haven't been enacted, and I took to heart what Thomas said and agreed very much that bankruptcy lawyers and professionals, restructuring professionals and investors, we find a way. We find a way to work through the problems and come up with creative solutions. In the U.S., in the Chapter 11 process, we have been undergoing reform under the bankruptcy code constantly, and we do it not through congressional action, but we do it through judge-made law. And when the bankruptcy code that we're using in the U.S. was enacted in 1978, we didn't have complex corporate structures that we have now. We didn't have derivatives. We didn't have debt trading. And so there's been a lot of evolving over the years that has addressed this stuff. But one of the things that we did do in 2005 was we signed up to the UNCITRAL model. We became a signatory to the UNCITRAL protocol. And what that did was it added Chapter 15 to our bankruptcy code. And very briefly, what Chapter 15 allows is it says if there is a foreign proceeding in another jurisdiction that is the main proceeding or you know, a proceeding where the company has its center of main interest, but there are assets located in the United States that need to be adjudicated, you can file a Chapter 15 in the US to recognize a foreign representative who can then adjudicate the assets in the US. And the best example, I think, that will resonate with people listening to this would be if there's a US bank account and the foreign proceedings would like to have access to those funds for distribution in their restructuring efforts. The US entity is not going to give that bank account to the foreign court without a court order from a US court that would protect them. And so the Chapter 15 proceeding allows for the administration of assets in the US in assistance of a foreign bankruptcy. Brazil hasn't signed up to the UNCITRAL model. And what that means is, while we recognize foreign proceedings, and OI is a terrific example, while we have the ability to adjudicate assets in the US under Chapter 15, we don't have the same ability or certainty to go to Brazil and say, we have a Chapter 11 in the US, and we'd like you to give recognition to that proceeding and understand that what's happening in the US is the real center of main interest of the company, but there are assets located in Brazil which we would like to have you adjudicate. We've lived without it, but I think it would be better to have that certainty that the courts in Brazil are gonna honor that. There are different ways and techniques to think about whether or not a company should file a Chapter 11 or a Chapter 15. And there are basically three of them. You can file a Chapter 15 in the United States here to recognize your foreign bankruptcy. But one of the other things that we've seen is filing a Chapter 11 in the United States and avoiding a filing in Brazil or elsewhere where there is uncertainty or delay, or it's not clear how long it will take. And the best example I can give of that is the case that we at Proskauer were involved in a year ago, which was the Westinghouse Chapter 11 case. And Westinghouse went into Chapter 11 in the US, but it had assets and properties all over the world. And what they did was they borrowed an enormous amount of money under their DIP financing and used that money to loan to their affiliates in foreign jurisdictions to keep them out of proceedings. In that way, they acted like a bank, essentially, propping up their foreign affiliates to avoid a restructuring or an insolvency proceeding in a jurisdiction where there was less certainty about what was going to happen. That's one technique. Another technique is in a case we were involved in last year, an oil and gas case. They did a Chapter 11 in the US, but the Chapter 11, this was a company that was traded on the Irish exchange. It's for tax reasons, it was domiciled in Ireland. But they did a Chapter 11 in the US, and they said that Chapter 11 will only be effective if there's a reorganization that's recognized in Ireland, or an examinership in Ireland that is recognized. So a condition of the effectiveness of the Chapter 11 plan is getting the foreign jurisdiction to agree that the Chapter 11 plan should govern the relationship with creditors. And then finally, another technique that we've seen, and this is something that I think all people should be looking at and thinking about when they're choosing where should they file and what jurisdiction works best, is filing a Chapter 11 in the United States can be fairly easy. And one of the things that we found that I think could bring clarity to the situation is an example of Pacific Exploration. It was a case we did a number of years ago, where it was a Colombian oil and gas company, assets in Colombia, traded on the Canadian exchange. So it was a Canadian company, but its debt instruments were governed by New York law. And most importantly, there was a choice of law provision in the debt instruments providing for that the appropriate forum would be the Southern District of New York. So it was possible to do a Chapter 11. And when we sat around the table and worked out the various jurisdictions that we could potentially file in, Colombia, Canada, the US, we came to an agreement that probably the best thing to do was to file everywhere. And we came to a negotiated settlement where we filed in Canada, we filed in the US in a Chapter 15, and we filed in Colombia under the local laws. All that is to say, every case is different. And when you go into these Chapter 11 proceedings or a Chapter 15 proceeding, you need to think about what are the various options and what are the advantages and disadvantages. There's no right answer for any one of them.
Tim, thank you very much. From what I understood, based on what you said and what Thomas was saying earlier, it's possible that the new Brazilian bankruptcy law will have a similar Chapter 15-like mechanism, which would mean that essentially then we're dealing with an equal deck both in Brazil and in the United States in terms of mechanisms that companies can choose. So if a Brazilian company were going through difficulties today, what would you say to it in terms of the advantages of doing a Chapter 11 or a Chapter 15 in the US?
So you have to file your main case in the jurisdiction in which you have the center of main interests. And you really do need to do an analysis as to where is the heart of your business? Where do you operate from? And that the COMI can shift. And we've seen cases, in fact, in the OA case and some of the other cases where there's been moving, people have moved their center of main interest in order to either take advantage of a particular bankruptcy regime or to avoid a disfavorable advantage regime. And you have to try to understand what are going to be the challenges that are going to come from your various creditor constituents and whether or not it's going to end up in a protracted case and how that's going to work. So while there are advantages to Chapter 11, it may not be available to a company where their center of main interest is in a foreign jurisdiction. So you may have to go down the Chapter 15 route. But one way to potentially avoid that is, I think what they did in Westinghouse was pretty clever, where they just filed the Chapter 11 in the US and avoided proceedings in the foreign jurisdictions by loaning money to them.
We had interesting, if I may, we had this discussion a few years back when we were representing OGX, and before OGX filed in Brazil, we had this discussion and this debate because there were foreign companies, issuers of the bonds. There were Dutch companies, Austrian companies. There was some involvement of the U.S. jurisdiction because the bonds were governed by U.S. law, although I think there were questions at the time if just having the bonds issued by U.S. law would be enough to do a Chapter 11, if I recall. This is maybe 4 or 5 years ago, or 5 years, maybe more than 5 years ago. But in the end, the decision was to file in Brazil for a few reasons. One, we had a feeling that the courts in Brazil would be, and in Rio particular, would be more protective to the debtor. And I think in that situation, the choice was even easier because the other alternative would be filing in the Netherlands. And as far as I understand, the Dutch proceeding is really creditor oriented, and also it doesn't have recognition proceeding, so it would create a lot of difficulties. So in the end, in the OGX case, for all those reasons, we decided to file in Brazil and then do a Chapter 15 in the US for recognition and to, you know, enable the, it was a debt into equity conversion, and we needed, you know, the trustee of the bonds to do the conversion. They need DTC to also work with them. They need a US court order for that. So for all those reasons, that was the decision that we took. I just thought that was an interesting case to comment.
If you allow me, in the same case, Ike Batista, who was the owner of the whole empire, OGX, OSX, and so on, he had created some companies which were supposed to own and lease FPSOs, these oil exploration devices. And we were representing the bondholders of one of these. It was a huge thing, you know, over $1 billion. And the biggest concern was that the owners were these Dutch companies, and they did not want to have this part of the Ike Batista involved in the restructuring in Brazil. So in those days, this was pretty new. You know, we didn't have so much experience with these foreign financing vehicles as we have now, you know, after a dozen of cases where this has been discussed. So we made sure that there was a recognition in the plans that these companies would be outside of the restructure. I don't know if Marcelo remembers that, but there were specific provisions keeping these creditors, which were creditors of these vehicles which own the FPSO, outside. And the main argument to keep it outside was maybe a little bit slim, but that's what we reasoned at that time, was that when Ike conceived the whole thing, you know, he started with an oil company, then he said, well, that's good, so why not own the equipment and lease it? And then he wanted to produce the equipment. So the second stage of own the equipment and lease it was supposed to be an international venture where they would own FPSOs all over the world. You know, the plan was to own, I don't know, 60 or 70% of all the FPSOs which were operating in the world. So we had some basis in terms of jurisdiction to say that the center of main interest of these companies was not Brazil, but it was actually the Dutch companies which were commanding a project which was much broader, you know, which encompassed the whole world market. You know, it was the way, you know, this entrepreneur thought. You know, the third stage was to have the yards which would produce FPSO. So he wanted to have the whole vertical chain in his hands. But at that point it worked, you know, so we kept it outside of the insolvency proceedings, and we have specific stipulations in the plan providing for it. So that worked quite well.
Thank you very much, Thomas.
You know, Tony, I wanted to add something that I thought would be interesting to talk about, and it's the 363 sale, the sale of assets free and clear. You know, if you have a Chapter 15 proceeding in the U.S., but the assets that you want to sell are not located in the U.S., you're still going to have difficulties and tensions, you know, selling the whole, and you know, maybe the other panelists could comment on what exactly is proposed in the 363 sale process, and how 363 like changes in Brazil, and what are ways that could work around that now in the event that the reforms don't go through.
It's a tough question, you know, Tim. It's not easy because right now Brazil has exclusive jurisdiction over insolvency matters of companies, and the term here is where the main establishment of the company is, even if it's a subsidiary of a multinational company. So it has exclusive. So it probably would not recognize a 363 sale in the US. Although this could be achieved, I imagine, you know, and you're the one who's going to tell us, is if you have a share sale in the 363 and not an actual asset sale or asset-based sale. If this could be structured in terms of an asset transfer, this asset transfer, you know, by some of the conflict rules could be considered to be effective and valid in Brazil, notwithstanding the exclusivity of Brazilian jurisdiction. A tough issue, you know. Have to go back to the books and to study it a little bit more.
Yeah, no, that's kind of what I was
would imagine that something like that, you know, might work in certain circumstances, as long as you could say that this was a transaction carried out of Brazil by companies incorporated outside of Brazil, and the fact, and this is done all the time. You know, we have several transactions of very large companies which are sold and have Brazilian subsidiaries. So there is a change of control in Brazil, but the sale of the whole is considered valid. So I would imagine that one could eventually use a 363 or even construe it the way you are imagining.
Right. I mean, if you have the shares, if the shares are certificated and you actually have the certificates in the United States, you could conceivably make a very good argument that the shares are under the U.S. court's jurisdiction and could be transferred. I think you'd have to go to the books. I think we'd have to go to the books as well on that.
Yeah, but it probably would. The share certificates of the Brazilian company wouldn't work. But if the share certificates are held by a U.S. company, a holding company, exactly, it might work, you know. So there is a line here, right? So if it's an asset-based thing, it probably would not be recognized. If it's not asset-based, but you know, these transactions happen the whole time, you know, where the subsidiaries are, the control of the subsidiaries are transferred indirectly. It's an interesting concept, Tim.
Well, thank you very much. That was a novel idea, Tim. You heard it here first. We have a question from the audience, which I will try to paraphrase. The question is from an investor's perspective. You know, liquidity for the company in any restructuring plan is essential. Now we've already talked about the importance of having a debtor in possession structure in place to finance the company. The question here is there a role for either ECAs or insurance programs or even governmental support to ensure liquidity so that a company has you know, a viable means of implementing its restructuring plan? And I'll open that up to any of the panelists.
Maybe I can take a shot here. It's a difficult question. We also, again, taking the OA case as a precedent, we had a lot of discussions by the time of the approval of the plan on the treatment to the ECAs. There were foreign ECAs right? Not a Brazilian ECA. They were foreign ECAs that were providing credit guarantee to the creditors that were basically suppliers of oil. And one thing that the company was really pushing by the time, and we were advising the ECAs on that case, but one of the things that the company was pushing was for a new ECA credit, like a deep financing on the plan, and it was, unfortunately, was something that we wouldn't. We were not able to negotiate that. So, but I think it was not a structural issue. I think it was really a negotiation or a commercial point with the company in that particular case. But I think, you know, other than that, it's not a very common issue here in Brazil. We have a similar issue now with another. It's also a listed company. It's also public, called Fertilizantes Ehringer, that also is having a discussion with the Russian ECA. We also represent the Russian ECA on that, but it's a big fight and not even close to a financing discussion, unfortunately. But again, I think there are all cases that the issues are really related to the company itself or to the negotiation, not a structural issue as a whole. I don't think there is any specific concern on that. I don't know if I answered the question, but that was my 2 cents on that.
I think you did your best. Thank you, Marcelo. Otávio or Thomas, have you seen any circumstance where an ECA or an insurance company has stepped in to provide liquidity for a company in its restructuring plan?
Well, what I have seen is sometimes to do it indirectly through suppliers, right? So you finance the supplier and and some of the other counterparties that are dealing with the company post petition, and that they feel actually sometimes more comfortable even that the company now is under court protection. So I have seen this done indirectly, not directly with the company.
What we have seen in the past is, you know, what Marcelo mentioned, that the ECAs, as in the OI case, but in a few other cases, they have credits against the debtor. And we've even represented in the past a few ECAs, and we had to deal with them also in some restructurings. But I remember a few years ago, there was an insurance company which was interested in this market, but nothing came of it. So I haven't seen them doing any dip financing here.
I think insurance companies is even more rare, to be honest. I think, you know, for insurance companies, there is also always a discussion whether, you know, they are pre or post petition, you know, assuming that they pay some insurance, and then they always have and I'm not giving any opinion here whether they are pre or post, but there is always this discussion if they can be post petition because they actually honor the guarantee or the insurance after the filing. And also we had cases on the construction companies that were object of the car wash investigation that ended up filing for RJ in Brazil. They all had performance bonds because of the constructions, and a lot of them actually got canceled, the insurance. So I don't think there is a great appetite of the insurance companies in Brazil for providing credit or insurance during an RJ. I think it's quite the opposite, to be honest, unfortunately.
Tim Karcher, I see you nodding your head. Was there anything you'd like to add?
No, I mean the insurance and bankruptcy post bankruptcy in the U.S. is, you know, it's an issue that we also struggle with as well.
Okay, thank you. Maybe that's a topic for another webinar. John Welch, I don't see that we have any more questions.
Yeah, I didn't see any either. Well, what a very excellent panel. Thank you very much to all of you. And thank you to Proskauer and Rose again for sponsoring this event. Thank you, Tony and Marcello. And thank you all for joining. I just wanted to remind you that tomorrow, Thursday, we'll have another webinar. And it'll be an open discussion on social media and brand marketing with Fernando Barreto of Let Go and Bruna Guazzelli of TBWA, moderated by Renato Camo from R2CW. So that'll be Thursday at 10 a.m. And we thank you again for all attending, for all of you for attending. Stay healthy and in good spirits. And thank you again for the panel.